What's up, everybody? We're back here at thctrust.org, and this is going to be the second video that we're doing with the Affidavit of Commercial Obligation. I'm going to try to get through this real quick, so follow along with me. For this video, you have to have a membership on a website. Everything we're covering is in the free area, so all you have to do is go down here, click this, and create a membership, and then log in and follow along. So get logged in here. And again, if you want to start that membership, and what that's going to do is give you full access to all of the topics that we cover, including the advanced topic. Right now, if you don't have a subscription, you won't be able to access these advanced topics. But today we're going to finish up, and to do that, you click this right here, and that's where the membership subscription plans are. So follow along. Remember, this is the second video, so you had to watch the first one first. If not, you can still watch it. Click here, Administrative Procedure. And in the first video that I did, I mentioned these prerequisites. So it's really important that you watch this first if you're pretty much new to this area of study. You know what I'm saying? So you could watch this and then read the article on this page, and then click commercial liens, which is a build on top of that. And then these are the different PDFs and documents. So we're going to look at today, we're going to look at the structure that we came out with when it deals with the affidavit of commercial obligation for perfecting a commercial lien against a surety bond. So as I spoke about in the last video, this is all about having had to go through that demonstration, learn and measure it up with the Uniform Commercial Code and make a couple tweaks here and there so we have something attachable and enforceable. But when you go back through the other videos, you can click this, and this is actually, these are some references. I think this is, what is this document here? Commercial liens, a most potent weapon. So you could read about this. This is one of the earlier documents that kind of broke that stuff down, but neither here nor there. Let's get to the subject matter today. Click at the Administrative Procedure menu. Click here where it says Lien Strategy. This was the first video in this series, and what you're listening to now is the second video, and it's going to also be in this area. Enforcement is a complex topic. It's nearly impossible to enforce what you do not know, and when you do know, it takes diligence, patience, and attention to details. Enforcement should be considered in the early part of making an inquiry, performing a transaction, and or having interactions with fiduciaries/public officials. Generally speaking, an administrative procedure should have an objective and a means of enforcement. The oath of office is your collateral, and it's your collateral to your security agreement. Your security agreement is what gives you an interest in certain property. In our case, the oath is your security agreement that gives you an interest in specific goods called performance-based obligations. And I mention it like this because I did in the last video too. After I finish reading through here, we're going to go down and look at how this lines up in the Uniform Commercial Code. But what we're going to see is when you put your acceptance on the written certified record, which is an oath of office, you've taken possession of collateral, you've established a security interest in proceeds, you also have formed your security agreement and your contract, because the offer and the consideration is the pledge within itself, and it's already signed by the debtor. See, when you look up security agreement, it's going to say it needs to be the authenticated record signed by the debtor. That's what the oath of office is. It's a pledge for consideration, and it's already signed and it's offered. So when you accept it, you are completing the requisites of forming the contract. Anyway, we're going to look at that next, right? But it's important, of course, again, when you accept it, that you got to give them notice of the acceptance. Now, another thing with the notices, which you have to understand, and we're going to see so that you can delineate, especially if you're new to this is that the notices is the part of the administrative procedure where you're still trying to get a resolution. The ultimate goal isn't to file a lien against someone's bond, it's to get performance, but to have leverage or enforcement or a area to go if you are damaged or injured because a fiduciary fails to perform when they are obligated to. So again, the notices are to give them inquiries that may become duties. So do me this favor, or do yourself the favor, go to Google, type Bouvier's Law Dictionary and the letter N, and look up the word notice. And it's going to not only tell you everything that needs to be in your notice, it's also going to tell you that an inquiry under a notice may become a duty. And this is what we do when we express our constitutional rights, because the Constitution doesn't seem to be the policy that they are operating under, but they have an obligation. So you have to give them, you have to give them notice. And that, like, for example, that notice might be notice of acceptance. You do the acceptance of office, binding them to their constitutional performance-based duties. And you might give them a notice of the acceptance of office. And in that notice, you're going to be setting forth the situation where you need them to perform. And you're going to be giving them the references of why it's their constitutional duty. So that's the kind of importance of notices. Notices don't necessarily have to be signed by any notary or anything like that, because you're just requesting that they're performed. And you can kind of say it's almost, in some instances, the notices might be giving them a warning that they need to proceed with caution because they may be about to violate your rights. It's when the notices don't work, it's when your rights have already been violated, that the affidavit of commercial obligation gets drafted and presented as a charging instrument. That's the acceptance for value on their oath of office is just for the inquiry under a notice where you're compelling the trustee to perform. It's only if they fail to perform is when you go into the affidavit of commercial obligation. Right? So I hope that's understood. Now also there's a link right here. You'll see this emboldened on the screen right here. I highly encourage you to take the time, because remember, as I was saying, patience and diligence is important. If you really want to understand further how this stuff is connected and to potentially be able to enforce and protect yourself, then you want to be very familiar with how the public officials bonds work. This document is called the Public Officials Bond, a statutory obligation requiring faithful performance. Right? Requires faithful performance, fidelity, and flexibility. This faithful performance is to the Constitution, because that is the only real contract that you have that's enforceable with them. A lot of times people think just because they're public officials, I can make them do this by writing a letter, and sometimes their administrative procedures have no basis. You have to have a security agreement to have something attachable and enforceable. So again, that's why we look at the oath of office, which is the pledge of collateral, and the bond, or the circumstance of the liability policy, the actual proceeds that support the bond, because that's the collateral interest. This tells you about the statutory side of it. Let me see here. For example, it says this article discusses the various forms of and issues relating to public officials' bonds. This relatively generic term relates to the bonds that are issued by the public official and the surety jointly in favor of the governmental entity and the public officials and the public officials served. These bonds are commonly required by statute and create a three-party relationship. And let me see. These instruments typically include the traditional two-party relationship where the insurer issues a policy or bond agreeing with the insured to indemnify the insured for certain losses arising from the dishonesty and or other enumerated conduct of its employees. The distinctions in terminology and coverages are important when considering and addressing issues that arise upon the insured or assured public entity's loss arising from the conduct of covered public officials and employees. And they also go in this article and they talk about bonds as opposed to liability policies. They really go into the intricacies and differences, and that's just some of the background information you want to know about if you're in this study of enforcement and protection of your rights. Also keep in mind that the authors of this document are not writing from the perspective of a secured party creditor enforcing his private rights by accepting an oath of office and compelling a fiduciary to perform. The way that we're setting this up is we're perfecting the security interest by taking possession of collateral. That's creating the private contract, and we're accepting, the collateral, or we're accepting the oath as collateral. So if there's a default, we perfect a security interest in the collateral and the proceeds under it, meaning that we basically have a judgment for a security interest in the proceeds of the bond, right? So we're kind of doing a prejudicial process to have a claim by contract. When you are doing administrative procedure, you are perfecting your claim, which is kind of like getting a judgment in the private before you get to court, if you get to a court. This is unlike a traditional proceeding where you get your judgment at the court. So what I'm trying to get you to understand is the judgment upon the issues and the facts and everything occurs in your administrative procedure. Anytime that you have to be in court after that is only a matter of collection and enforcement. It's not to reinvestigate what has already been perfected. It's not to prejudice your rights by depriving you of your security interest that's already perfected. And this is why if you find yourself in any kind of court, it's not so much about the court, it's about the jurisdiction, and you need to be in the admiralty or maritime jurisdiction if it's about enforcement of your claim. That's just, my thoughts, but again, that's beyond the scope of this, so I didn't even really want to go there. But what I did want you to understand, as you'll see when we get down to the affidavit, is that we're perfecting a claim, we're perfecting a security interest in collateral, right? Is already pre-adjudicated. So all we're trying to do is we might have to show up wherever that debtor is incorporated and file a claim in their United States District Court, an enforcement action on the actual proceeds. You see how that goes? We're not asking to get a judgment. We just want an enforcement action on our contract. That's why they foreclose on you in the United States District Court. Those are quasi, well, maybe it's not. They don't only foreclose you on you there, but those are maritime actions. The enforcement on property like goods, forfeitures, seizures, cease and desist. These are like maritime, quasi-maritime things. But anyway, also we're building a security. This is another reason why we're making sure that we're lining everything up with the Uniform Commercial Code, because we're building a securities so that we can use it in commerce. So the enforcement may happen in commerce, it may happen in the court. You have a security agreement, so you could get enforcement in any court, ideally. So I just want to kind of get you to understand you're not going to court looking for them to agree with your judgment. You already have that consent. You're just going to get enforcement on the collateral under that security agreement. So the beginning of your administrative procedure would start with giving a notice, an inquiry under the notice that would eventually become a duty. You're compelling the trustee to perform. The objective of your notice might be to present your point of law, which is the basis upon which you're compelling them to perform, and it's going to arise from the United States Constitution or your state constitution or some type of law enacted by your state. So under your inquiry, your notice to the proper officer who has the duty and the obligation, you will give them that written notice, and you'll be able to prove that you've given them that notice. And when you look up the definition of notice, notices don't have to be acknowledged by a notary, nor do you have to put a jurat on them by a notary, because it's just a notice. So, some people think they have to put an affidavit on all notices. Now, sometimes, there may never be time to give a notice. The trespass may already occur, so your affidavit of commercial obligation might have to be a notice also. So, just, that's why you have to take your time and be patient and look up all of these words. And, right? Now let's look at the Uniform Commercial Code real quick. I'm going to go through this real quick because we discussed most of this in the last video. What you would do is go look up all of these codes, because I'm just paraphrasing, and then I'm giving you the Uniform Commercial Code as a reference so you can see how it links into exactly what we're talking about and what we're doing. So before you have attachment and enforceability in a collateral interest or proceeds, you have to have a security agreement. That's what the Uniform Commercial Code wants you to have. So if you ever found yourself in a position to collect, you're going to have a security agreement. Your security agreement is the oath of office. As a record, it's signed by the debtor or the obligor. And when you look up what a security agreement is in the Uniform Commercial Code under UCC Article 9-102, Section 74, it's going to tell you that it's a certified record signed by the debtor, right? So that's why, and it's an agreement, and it's also a contract. So that's why you want, that's why the oath is also the consideration, because it's a pledge. You put your acceptance on it, you complete the requisites for a contract. Now you have a security agreement under UCC 9-102, paragraph 74. And then if you look up UCC 9-102, paragraph 12 for the definition of and the collateral, you're going to see that the certified record or the oath as a pledge, right? Because an oath is a pledge, it's an offer. Once you put your acceptance on it, is the collateral. So now your acceptance of office on the document is now a security agreement, and it secures an interest in collateral. Under UCC 1-201, paragraph 35, it gives you the definition of a security interest. A security interest means an interest in personal property which secures performance of an obligation. Again, what does that show you? That's what the oath is. So when you put your acceptance on an oath, you create a security interest. Your acceptance on that actual certified record is a security interest. You make that acceptance, run it through the copy machine, and send the affected party notice that you've accepted their oath of office. But you keep the originals, because that's your original security interest, and as we're going to see, it's also chattel paper. All right. So the certified record of the oath, together with your acceptance upon it, is chattel paper. Why? Because there's the commercial obligation, which is the bonds that support it. Well, let's look at the definition down here. Chattel paper is a record or records that evidence a monetary obligation. That's the bond backing the oath. So once you find the statutory code that there's a fidelity bond backing the oath, there's your monetary obligation. And the security interest in specific goods is your security interest in the performance, because that is what was under the pledge. Those are the specific goods. Your acceptance on that is the formation of that contract. Your acceptance of the oath creates a security interest. This is chattel paper. I already gave you the definition of collateral. Now, this is important to understand. UCC section UCC 9-313, paragraph A. Let me read what this says. It says, a secured party may perfect a security interest in negotiable documents, goods, instruments, money, or tangible chattel paper by taking possession of collateral. So the certified record of the oath and remember that's the chattel paper, right? It's part of the record of the monetary obligation and the security interest. So this is telling you that you can perfect a security interest in this type of collateral, which is tangible chattel paper, by taking possession of it. So again, the reason why we want to perfect a security interest is because ultimately we want to make sure our contract has enforceability under the Uniform Commercial Code, because the Uniform Commercial Code is used to determine what type of rights and interest a creditor has against a debtor or a debtor's property when he's holding a contract. That's why we're lining all of this stuff up. So, but if you look up UCC 9313A, and let's look it up, I'm going to show you something that I kind of noticed here. Notice what this says under this section. When possession by or delivery to a secured party perfects a security interest without fouling. So they're saying when you take possession of this tangible chattel paper, by taking possession of that collateral, you've perfected a security interest in the oath of office, and you don't have to file a UCC 1 on it. So, but according to the commercial law, you perfected a security interest in those specific goods, which is performance. The security interest is in the oath. The oath is for performance. Your specific goods are performance. I'm breaking it down like this for a reason, and hopefully you will see, and if not, you got to go back over this and read it for yourself, and it'll start clicking and coming together, right? So we're going to go back to perfecting a security interest in tangible chattel paper by taking possession of it as collateral. Now, here, just real briefly, I put an example of my type of acceptance, just the ideal generally of what I mean when I say accept the oath of office in writing. Go down to the county, get a certified record of the public official or deputy, whoever you're dealing with, get a certified record of their oath. And then on a separate piece of paper attached to it, I accept your oath of office attached as document number whatever, and appoint you fiduciary to faithfully carry out the duties set forth herein. Whereas based on the Constitution for the United States, Article 1, Section 8, I am entitled to, or I have a right to, blah, 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 blah. And from there, that's your inquiry, your acceptance of their oath, and your inquiry where you're compelling them to perform, your formation of the contract. So you would send them that notice of the acceptance of the oath with the copy of your actual acceptance, but you would keep the original, right? Now, if they didn't perform and they ignored it and they just took you for granted and you've given them plenty of notice, this would be the basis, this would be the contract from which you now can base a claim off of. You can bill them based off of this account or based off of this contract. And this is where the affidavit of commercial obligation comes in. It's a charging instrument in commerce. So I'm going to try to explain this concept. I want you to wrap your head around this, because I think if you can understand this relationship to the proceeds, the slight difference between proceeds and collateral. Because when you look up proceeds, you're going to see that they are also collateral. But what I'm trying to show you is our process is for attachment and enforceability in the proceeds. And it requires the filing of a financing statement. You have a contract. The Constitution, contract, trust is your terms and conditions they gave an oath and allegiance to. If a default occurs under that, your perfected security interests in the oath as collateral is already a perfected security interest in the proceeds. However, the part that's not done is the filing of the financing statement, which is required, right? So the proceeds are the objective of the affidavit of commercial obligation. That is the bill, the bill on the account. So ultimately, if you were to file a lien to perfect your security interest in these proceeds, you'll file a lien on the actual bond number, but you would have to have a charging instrument behind that to make it correct. And that's where your completed affidavit of commercial obligation would be behind it. That would be part of the record or the chattel paper in the filing of your commercial lien on the bond. But you can't have a perfected security interest in proceeds without having already perfected the security interest in the collateral, which is why with your affidavit of commercial obligation, behind that you have to have your original contract, right? Which is the perfected security interest in the collateral. That's the oath of office as a document with your acceptance. That's your security agreement. Okay? So that's what will actually be behind your lien. And down here, this is important. This is under UCC 9-315 section E. It says when a perfected security interest in proceeds becomes unperfected. It says if a filed financing statement covers the original collateral, in which our case it does, because that's the oath, a security interest in the proceeds which remains perfected under subsection D1 becomes unperfected at the later of 1. When the effectiveness of the filed financing statement lapses under section 9-515. Sorry, I got a loud plane flying over. Okay, so the security interest in proceeds becomes unperfected when the financing statement that we just talked about and everything behind it, when it becomes terminated under section 9-513. That section, I believe, is pretty much telling you it's effective for 5 years unless it's renewed. But this is the part I want you to pay attention to. Or the 21st day after the security interest attaches to the proceeds. So what this is telling me is if you accept someone's oath of office, now you have your contract, you give them the notice, the performance-based obligations under the Constitution. If they ignore that and you have to do an affidavit of commercial obligation, a charging instrument, to charge them with the specific offenses, then once that's perfected, if you don't file a financing statement within 21 days after their default, then the security interest to the bond and the proceed does not attach. And I guess it's really, not any good. So it's like, to me, that seems like once you perfect your claim, you have to file that financing statement within 21 days. Hey, and then that's the key. So let's now look at the affidavit of commercial obligation. All we have to really do is read over this, because if you went through the other, administrative procedure videos that come before this, and you just went to all these videos up until now, you will understand the structure of this instrument. Now, it's important to know that this particular affidavit does not relate to any specific situation. This is just the outline or the framework of how we're setting it up to adhere to what they call that the four corner rule, right? There were some comments about that on the last video, so let's look at that real quick. The four corner rule, according to Google, four corner rule is a rule holding that if a document as a contract, deed, or will appears on its face to be complete, no outside evidence may be used to challenge it. And then they have a note that the number of states that accept the four corner rule is in decline. Okay, so as we see, the affidavit, okay, let me talk about that real quick. It doesn't really matter that the numbers that accept the four corner rule is in decline because, well, my understanding is this affidavit, as we just discussed under the UCC, we have a security agreement, we have a contract, right? It's authenticated by the debtor because the debtor actually signs that oath record. So we are not taking this into a judicial court to get a judgment, right? We already have a judgment on the facts, the issues, and the matters. So if this finds itself in any court, we're not worried about the state, because my understanding is we have to then be in the admiralty jurisdiction, because that's where all the officers, municipals, agencies, and fiduciaries, they waive their sovereign immunity. So in the maritime admiralty courts, or maybe it's the United States district courts where they have these quasi-admiralty maritime claims, these are the jurisdictions where you're dealing with enforcement or seizures, forfeitures, and claims processing. So you go in here with already a perfected claim. You go in here already with the security agreement and a security interest. You're not going here to get a judgment. You're just going in here to get enforcement on the collateral that you already have a perfected security interest in. In our case, we're dealing with the proceeds. So this is kind of the contract, that you would be getting enforced. Again, it'll be behind your UCC financing statement. And it's a security within itself. It's a security interest. If you found the right broker custodian, they can put it in some type of custodian account so you can leverage it or use it as collateral. But also, if this did end up in some type of court, it's not about whether the state adheres to the four corner rule, because you're trying to be within the jurisdiction of the admiralty, which is outside of the jurisdiction of the state. It's kind of, it's the place where the United States waives their sovereign immunity. So just consider it like that. That's where you have to be if you're proceeding against their bond as property, right? So that's beyond the scope of this. That's what comes after this, what you have to look at. But you can't even consider that, and you can't even consider this, does this work, unless you build the proper claim. Here's our claim. Okay. California, it's expressed in the form of an affidavit. You might want to consider underneath this caption putting in the common law jurisdiction of, or something like that, to reference the common law. It's just something you may want to consider. And this is the affidavit of obligation. I, John, of the family Doe, as commonly alleged, being the undersigned, hereinafter affiant, do hereby affirm, declare, and depose that I am competent to state the matters set forth herein, that I have first-hand knowledge of the facts, that all the facts stated herein are true, correct, and etc. And then we get into the maxims of law, that the eternal, unchanged principles of law are, and then they list the maxim of law. A workman is worthy of his hire. All are equal under the law. And now that I'm reading this, I have a document that breaks down the reference for each of these maxims. So make sure that's going to be also included on this page. So when you log in and you actually follow this, make sure you're reading all the references. So you want to include these unchanged universal principles, right? And these are all being expressed in the form of the affidavit. And you already know how that works with the you're getting a judgment on these facts, these issues, and these matters, and you're getting their acquiescence. So we're laying out everything. We're laying out the entire trial, but we're expressing it in the form of the affidavit to get our private remedy. The purpose of this affidavit is to impose a lien on the collateral to secure payment for charges or damages and claims based on the following account, right? Something to that effect. Look, I'm going off in my head, so if you might be more knowledgeable than me and tell me a better way that this thing should be worded, but you get the idea of where we're going. So we're real clear about the purpose of this claim. The parties: John Alex Doe, the lien claimant, or you might come in the position of the executor, and then the lien debtor, Jerry M. Jones, which in our case would be the public official, and you would write that name. I would write it at least in one form as it's written on the oath of office. And then statement that, the affiant on January 5th, 2019 at approximately 09:45 a.m. And then I would just be laying out the particular occurrences. Here you are giving an overview of the events and the account that lead to and indicate the claim. Make sure to cover also right here in this overview, basically the background information, you will cover your interactions with the public official, the notices that were given. And now another thing, when you write, you could just allege, basically, you gave the respondent notice by mail on January 8th. You don't have to put the certified mail number and all of these things. That is proof that you never really even have to put in here. It's only, you will only produce that if they wanted to rebut the statements that you're making here. If they wanted to respond and say, you didn't give me notice, or I haven't received notice, then you would come and bring your evidence. But until then, you just make the allegations because they're truthful and they can be supported, and you really want to keep this administrative process as short and concise as possible. So as a little nugget, something to learn that's going to increase your performance or your procedures here is, when you're building these affidavits of commercial obligations, you already can prove that the notices was given. You don't have to prove that in the affidavit. It's a non-factor unless they challenge it. And then if they challenge it, you have the proof, right? Okay. So also, I want to encourage you to look up the word indictment in a Bouvier's Law Dictionary and a Black's Law Dictionary. One of them kind of gives you a real clear indication of everything that needs to be in an indictment. It is similar to the same allegations and the structure that you're going to want when you make a claim and you give somebody this private administrative trial, if you will. So let's go down to, here's some, respondent never disclosed to the affiant that whatever. That might just be a statement that you make. Respondent willfully withheld the record subject to the affiant's request dated, whatever. Affiant at no time has agreed nor consented. These are just, I'm just giving you ideas. These are things that might be stated. But you really want to be clear and concise and cover everything. And then we get into the collateral. Respondent's oath was accepted as collateral and is in possession of the affiant to secure. Let me try that again. Respondent's oath was accepted as collateral and is in possession of the affiant to secure the performance-based obligations herein described. I would take this UCC reference out here. I was just kind of putting it in here for my own notice how this lines up to the UCC. Basically, I've taken possession of the collateral. Now I've perfected a security interest in the collateral, and it's my security agreement. So I'm just being clear that under this charging instrument, the collateral is the oath of office. Right? I don't need to name the proceeds because the UCC has already told us that if the security interest was perfected in the collateral, it's automatically perfected in the proceeds. You just have to file the financing statement against, as a lien against the proceeds with the claim and the contract, right? That's what I was trying to express earlier. So that's what my little note was there, but you don't really have to put the UCC in this affidavit. It's an affidavit of commercial obligation. Technically, it doesn't see the UCC. That's something else to consider when you're writing out your affidavit as a charging instrument, because you're kind of like proceeding based on your rights, which puts you, standing in law, so to speak. So after that's perfected, you bring it into commerce to process it as a claim against the collateral, because you have an attachable enforcement interest in the collateral and the proceeds. So you're bringing it into commerce as a creditor. with a claim. But when you're actually lining it out, you kind of are blind to the UCC. The UCC doesn't exist to you. You're just proceeding, perfecting your claim according to the record. So don't, you probably don't want to put these codes in here, but you can use them when you're studying to reference. So we had the purpose. We clearly identified the purpose. The affidavit is to oppose a lien on collateral to secure payment for damages, charges, or whatever. And we can put that because the inquiries and the notices and the damages already occurred. Here's the account. We give the whole background of the story. We go to the collateral. We go to the collateral under the security agreement, which is, we're naming it here, but it was also secured with the acceptance of the oath. Now we go into the allegations and the claims. The respondent, by refusing to do whatever, as set forth in paragraphs 8 through 11, committed an offense or a crime. So basically what I'm saying, and you have to find out the proper way to word this because I'm still working on this. I'll be in here working on it. But these allegations and these claims have to come out of this whole account. This account is an overview of the story of everything, just like a quick narrative of the entire event. And these allegations and the claims are direct indications of how such behavior or activity was a crime, violation, offense, or how it violated your rights. So that's what's going to be spelled out. These are your claims. So the respondent, by refusing to do whatever, it demonstrating the behavior, committed an offense, or the respondent did in fact commit a crime when they did whatever. Spend some time figuring out how to make those claims, allegations, indictments, because those are the charges that you're charging them with. But again, they have to be well spelled out, and they have to line up with your notices and the events that occurred. Because if these things did really occur and you're documenting them correctly, there's really no way that they can respond to your allegations, right? And it's also important that these allegations are directly related to their performance-based obligations, which are directly related to your constitutional rights. Because wherever you have rights, someone else has a duty. So your allegations and your claims have to be based off of not opinion and how you feel and the things, how bad their attitude was, but these specific performance-based obligations that they were required to perform. So those are constitutional and they're lawful when you appoint them as fiduciary to carry out the law. Like in the example of discharging, because you can't pay for anything. So as a fiduciary public official, you're appointing them to carry out the duty for you. So, so that's where your allegations come from. And in each allegation, you should cite that specific constitutional violation or that specific penal code or whatever law that you're dealing with. And then down here in amount due, demand is hereby made for the total sum due of whatever amount on the above account, calculated as charged. $10,000 charged on the account of paragraph 11. $10,000 charged on the account of paragraph 12. And if you look what I was trying to do here, you can't see it here, but imagine this was paragraph 11 and this was paragraph 12. So paragraph 11 is an allegation. And paragraph 12 is an allegation. This is $10,000 based off of this allegation, another $10,000 charge based on whatever allegation. This is, now it was taught, I would say if you're proceeding against a corporation that have violated your rights, you might want these numbers to be sky high, like hundreds of thousands, if not millions. But if you're proceeding against a public official's bonds, make them $10,000, $5,000. That's what I'm going to do, because these bonds are usually $100,000 anyway. And the whole thing is, any type of claim that's done the right way, I think you're going to get the expected results. But anyway, make sure you have your ledgering, because if not, your commercial lien doesn't have any value to it. So your affidavit of commercial obligation is a charging instrument. It's a bill. It's like a draft on an account, right? If there's no value on it, then it's worthless. So you have to calculate an amount due. And now here's the next section, governing law. That the claims made by this affidavit are based on obligations arising from A, the oath of office, B, the United States Constitution, C, California Constitution. And then I put the California Penal Code, but this will be any law. Make sure we're not talking about legal codes, but laws that you're relying upon that went into your notices and your inquiries that, so you see how that all is laying out. So you're already establishing the governing law, the contracts, the oath, the United States Constitution. Now this is important. You can go look this rule up. Let's look it up. The Nisi rule. You can look it up in the law dictionary, but we're just going to do the Google way for now. It's a little bit further. It seems a little bit a step. How can I say it? A little bit more advanced as technology, let's say, than typically, the tacit acquiescence clause of not responding. So, Nisi rule. A decree nisi or rule nisi, from Latin nisi, meaning unless, is a court order that will come into force at a future date unless a particular condition is met. Unless the condition is met, the ruling becomes a decree absolute, rule absolute, and is binding. So we're establishing such a ruling that unless a certain thing is done within a certain amount of time, then judgment upon the facts and issues comes into the effect within 30 days after the presentment. And we're kind of doing it this way because this is still a contract and a claim under the contract. So we're still perfecting the claim part of this contract. And if we are trying to get enforcement against the proceeds in the maritime or admiralty, or just let's just say in commerce in general, then we have to already have the perfected security agreement in our contract and the default there too. We don't necessarily have to have a judgment. And if we always think in terms of we have to have a judgment, that's going to keep us looking at the statutory state court for a remedy. And that's not where the remedy is. If we're proceeding against a bond, we need to be in the jurisdiction where the sovereign immunity of these foreign agents or public officials, where their sovereign immunity is waived. And that is admiralty, maritime jurisdiction. But if we're not talking about court, that's in commerce in general. Okay? So here's the Nisi rule. The statements and claims presented by this affidavit, as well as any rebuttal or default hereto, shall evidence judgment upon the charges, amount due statements, and facts of the matter, wherein the points remaining unrebutted in the end stand as true, and the matters to which the judgment of law is applied, coming into force and effect after 30 days upon the issue of any default to this claim, and provisions and the time allowed for response. You may can tighten that up a little bit. And then after I give that rule, so basically what I'm saying is judgment comes into effect on the amount due, the claims made, the facts, the statements, the allegations, everything. Judgment comes due upon those issues within, and it comes into force and effect within 30 days, right? So how you word it is important, because really what we're establishing is the rule of this procedure, more or less than a judgment, because we could care less about a judgment, but what we really want is a perfected security interest in those proceeds so we can get enforcement on our contract or on our claim. So we want judgment on the facts and the issues and everything spelled out in here. We already said what the collateral is. So I hope it makes sense what we're trying to do. And then we get into the terms of response, and you guys are already familiar with this. Any rebuttal shall be made by counter affidavit on a point-by-point basis, mailed to the undersigned and the notary, addressed within 10 calendar days, etc., etc. Also, like I said, I see uniform commercial codes in here. These things, just understand, I'm sorry, I got to take this out. These won't be in your affidavit. You don't want to cite uniform commercial codes in your affidavit. Once the affidavit is perfected, you know, the uniform commercial code is what you're going to use to deal with this as a security or some type of investment property in commerce, so that you can go after the proceeds. So anyway, I hope that was clear what we were trying to demonstrate. What we're trying to demonstrate is once you run your administrative procedure with this affidavit, ultimately what you're doing is you are perfecting a claim in this collateral interest, which is the oath. The oath is automatically connected to the proceeds. So you just want to make sure that this rule goes into effect so that judgment comes into force and effect on everything that you've stated in here, including the claims for the damages and the amount due and everything else, right? All of that is the support that you would need behind your lien on the actual bond policy, right? So now if you really want to take this to a all another level, and then I'm about to close out because I've been going at it for a minute. For those who are Moorish Americans, you know, so let's say you perfect this, right? Then you deal with the Uniform Foreign Judgment Enforcement Act because you might authenticate your records. You might authenticate these records because you're going to take them into a foreign jurisdiction. You may find out where, once you file your UCC, because you got to do it in that 21 days and it's perfected, it's already perfected, it's done. But you may go into the state where that fiduciary lives, or maybe even where the bond is held, and you may file a proceeding in the United States District Court to go after the proceeds of the bond, and you may bring your record. But if you do that, you want to be within the admiralty jurisdiction. And on that note, please read this document. It's called Why We Are in Admiralty. Where is it at? It's on this page somewhere. If not, I'm going to make sure I load it up here. I will load it up here because that's a document that was written by, I'll put it right under the UCC connection. It's going to be Why We Are in Admiralty. And that'll probably help you further understand why in the law with our administrative procedure we perfect judgment against the proceeds and the collateral. We perfect the claim. We don't go into the statutory courts asking for judgment. We perfect judgment on the facts and the issues and on our contract. And then if we want to get enforcement, we might take it into we just take it into commerce. And I say take it into commerce because I believe that proceeding against the bond in a United States District Court in the Admiralty jurisdiction is something that can be done, but I also believe it doesn't have to be done. You can just form the right relationships with the right brokers who can open up the right accounts and handle the chattel paper for you, so you can, just handle it that way. You don't really need to go get a judgment, but you might need the assistance of the court to go after the proceeds. Anyway, listen, I hope that made sense. I hope you were able to follow along. Right now, please take a moment and like the video if it was informative.